Other things I talk about with the jury trial is that it's going to be time consuming. It's like going to the airport but not knowing exactly when the plane's going to leave. You might be somewhere between 1, 2, 3, 4, and 5 on the jury list, and if 1 and 2 settle, you have to be on standby, and you might have to show up and then be excused and then show up again the next day, and it can be a little flustering. You just gotta weather that storm. And remember, that's at the end of the entire course of litigation. So it's something to prepare for at the end, but don't let that anxiety bother you when it's the first kickoff. It's not something you need to let stress you out at that point. And then other things like, for example, appeals and all that, I generally tell clients, don't worry about that at this initial phase. If we look to that later, that's something that's a bridge that we will cross. Usually refer you out to competent appellate counsel, and let a client take a shot at overtime or defend the other party's shot at overtime down the road. But that's not something to focus on during the initial consult, generally. So that leaves us with the scope of representation and the actual contract between the law firm, the attorney, and the disclosures in that contract that allow us to be contractually bound to have that relationship with that client. And I'll jump into that next.